Heyo, folks. Welcome back. Uh, the thing caught my eye, and then I brought it back. No. Hello, everybody. How are you doing? Hello, you guys here on YouTube. Hello over at X. I haven't had time to set anything up on Rumble, so I will do this as a video of sorts. But first of all, let's say hello to my first and best moderator. It's Gigi. Gigi is here. Everybody say hello to Gigi. See, Gwendolyn is here. Nicola Cox is here. Vice baby. Jon Schön. Sock Snatcher. Ayo. Erin. Chicken poo. All right, good to have you all here. Oh, yeah. Now you might wonder, what is this new Fani Willis screw up? Well, remember, maybe it's even a couple of weeks ago, I covered the Judicial Watch, the Fani Willis versus Judicial Watch thing. This is where Judicial Watch said to the court, we want papers from the Fulton County DA's office because we believe they were colluded of sorts together with people in the White House. And of course, D.A. Willis, since she's an upright and upstanding citizen, she said, what documents? What documents? I don't know anything about any documents. Well, that is also the Freedom of Information Act, where eventually she didn't bother to show up in court, so they fined her close to $22,000 for not showing up in court. So, a week and a half ago, they decided to send the lawyers. And and then something really, really interesting happened. And now, you guys know me, I don't like to get political here. I really, really don't. I want this to be a political free zone. There's enough politics out there somewhere. Don't want it here. Yeah. Now, Judicial Watch has a somewhat political view on it, so I will simply let them speak for themselves, how they feel about this. And this is Tom Fidon, who is who are you? He is the president of Judicial Watch and the fact checker and stuff. So let's listen to what he has to say about the latest development in the Fani Willis thing.
They went from having 0 records to 212 pages of records about their collusion with the Pelosi January 6th operation to get Trump.
Is sound okay?
Just before this report to you, I was on a Zoom participating virtually in a state court hearing in Fulton County, Georgia, on the Fani Willis documents scandal that Judicial Watch uncovered. As you may recall, Judicial Watch filed a Freedom of Information or Open Records Act lawsuit in Georgia against Fani Willis after she didn't turn over any documents or responded responded with as I keep on saying, a hand to the face for our request about documents with detailing any collusion she had to get Trump with Jack Smith operation and the Pelosi January 6th operation. And more or less, she said, 3, 4, 5 times, I don't have documents. And even worse, she didn't even show up in court to answer our complaint. So she was found in default. The court noted that the searches were just not real searches at all. She admitted that there were documents after telling us and the court repeatedly there were no documents. The court ordered her to pay Judicial Watch's fees, attorney's fees and costs. So her operation had to pay us nearly $22,000, but we still don't have the documents. So the judge, and we've been asking for a special master, which would be a judicial appointed individual, usually like a retired judge or an expert lawyer, who would oversee a legitimate search of records. And so, they tell us they have no records about the collusion. And then they say, we do have records about the collusion. And the only record they released was the one that we sent to them to show that when you say you have no records, you're lying, because Fani Willis herself wrote a letter to the head of the January 6th committee.
Yeah. If you say, remember, Fani Willis is an attorney. Fani Willis is an officer of the court. You have candor to the court. You have, in that are ethical responsibilities. Don't lie to the court. Now, we all know that Fani Willis lies in church and was very, very liberal with the truth in court filings. So we are not surprised. But that is when she was only her writing things for her boyfriend. Now she's representing things to the court and has done so for a long time in this particular matter. That there are no documents. And in that, she's representing the entirety of the Fulton County District Attorney's Office. That's a bit more. And that is also, in my personal opinion, Fani, if you're watching this, which I assume you don't, but if you do, then that immunity thing, no, don't lie to the court. Thank you for Dali for rating. Thank you, Dali, for rating us. A Dali raid. Oh. And hello, Dave. So let's see here how this develops.
Then they come back and say, we did find records after all. Today at the hearing, in a hearing over our request for a special master, they said they did another search, and now there are 212 pages of records.
212 pages suddenly appeared when they did a new search after the court decided to fine them the attorney's cost. Oops, we found. Whoopsie. we just happened to. They only knew about the one, so they assumed that we were lying, which we were, because provably at least one document existed. And 212 suddenly appear. These guys are worse at finding stuff. No, not worse, but folks, remember the YSL trial? All these documents that they don't exist. We pledge our honor. Something. Yeah, as it turns out, maybe the Fulton County District Attorney's Office at the regular needs a special master that appointed by the court to, okay, now I will search for these records.
Can you believe it? So they went from having 0 records to 212 pages of records about their collusion with the Pelosi January 6th operation to get Trump. The court during the hearing held in abeyance our request for a special master. I think he's hesitant to do that. It's extraordinary in some ways, but on the other hand, this is an extraordinary circumstance. Never in Judicial Watch's history of hundreds of Freedom of Information Act lawsuits has a government agency been found in default because they couldn't be bothered to show up to answer the lawsuit. It's incredible. And on top of that, they did multiple searches, pretended not to find anything, or did fake searches. And then they telling us they have no records, and then they discover records. Each search, they find seemingly more records. And now we know they're 212 pages when they said they had 0 pages to begin with. All those circumstances suggest they can't be trusted to tie their own shoes, let alone search for records in an honest way. Hence our request for a special master.
Yeah. Can't be trusted to tie their own shoes. Now, this should bother everyone. It shouldn't not be, because Judicial Watch is, well, something of a conservative think tank or whatever's. It doesn't really matter if you're conservative, liberal, even socialist, or a centrist, or whatever. This should bother everyone, because here you have a district attorney's office led by a district attorney who, in my personal opinion, has been caught in lie after lie after lie after lie. If I were a Democrat, which I am not, I would be absolute. How dare they tarnish the good name of Democrat, U.S. Democrats? How dare you? I mean, because this tarnish everybody who is in support of Fani Willis, which is why I really want to know who exactly showed up on Fani Willis' inauguration gala. Because, in my opinion, these people support a liar in church, a liar in court. I mean, why do you keep throwing money at Fani Willis? Now, I understand if you throw money at Fani Willis because this is what you want. Because you want a stooge holding a elected position. But the rest of you, seriously.
But in the meantime, the judge says, you know what, I'm going to look at these documents because you're telling Judicial Watch they can't have any of them. It's 212 pages. I can look at them directly. So Fani Willis today, her lawyers admitted that they have 212 pages on collusion targeting Trump. Now, they're not going to say it was collusion targeting Trump. That's my term. But I'm fairly describing what the issue is. They were coordinating with the January 6th committee on the unprecedented prosecutions of Trump, not for doing anything illegal, in my view, but for exercising his core First Amendment rights his obligations under his oath of office as president of the United States to make sure the elections were run correctly in Georgia. So again, Judicial Watch's heavy lifting repeatedly gets more and more results with this Fani Willis scandal. So Fani Willis admits to having documents. She's forced to pay us $22,000. We find out the documents are even more than anyone had previously admitted to, 212 pages. And the court said, I want to look at the documents.
Yeah. And so the judge clearly is not taking Fani Willis or the DA's office at their word. Because, here you are with 212 pages, but you don't want the opposing party, Judicial Watch, to see them. Well, I'm going to take a look at them, those pages, those documents, and I determine who gets to look at them. So more or less, the judge now is the special master of sorts. Because it might be that there are documents in there that is not for public view. I can't think of a reason, but there might be some legalese involved. But I would be surprised if this judge, who I believe is Judge, what's his name now? Oh, I know his name. I have it here. Dun, dun, dun. Hold on. Judge McBurney. Atlanta judge, a Fulton County judge. So, Judge McBurney. Let's see here. Yeah, he had. Oh, wow. As with. This is interesting. Judge McBurney has a YouTube page where he streams his court. So that could be something after we are done with this. Let's go to his court and see how he acts in other cases. But yeah, so Judge McBurney, it seems as because I mean, already ordered A, pay the fees, and now you all of a sudden found 212 pages. You all of a sudden you say, but don't show it to opposing party. It seems like this judge is not buying it. And it is reasonable after all of the shenanigans that is being pulled by Fani Willis, the DA's office attorneys, from 0 to 1 to 212 pages, that there is more. There is more.
Here is where the court essentially directed or told, our lawyers, our Judicial Watch lawyers, and the government what he was going to do, which is to order the records be turned over to him for review. Let's go here and listen to what the judge said.
Have I said things that leave either side with a lack of clarity as to what's happening next? Because I don't mean for that. I know it's a little bit amorphous because you want some time, Mr. Monroe, to consult with your client and flesh out, here's what I, meaning plaintiff petitioner, would like to see in this affidavit describing how the search was conducted. I'll enter an order that says I'm taking this under the 212 pages in camera to review that. So that's in the record. It's in the transcript right now, but that ought to be demarcated on this date. County attorney, you got 4 days to bring me the documents, or 48 hours, or whatever it is. And then we'll all know where those are, because if I get distracted by something else that maybe happened in 2024 and there's someone sitting in jail, then you'd be able to say, Judge, you've been sitting on only 212 pages for a month. that's, 12 hours a page. Let's go. So you're right. I got to turn back to that. But at least there'll be that marker saying, here's where we are in the process.
So right now, we don't know what the documents are, what they say. There are all sorts of privileges being asserted. Whether we can smash through the wall to get to the privileges, to get to the documents and overcome these exemption assertions is kind of going to be another matter. But the fact is, we now know hundreds of pages of documents exist detailing collusion between Fani Willis and the Pelosi operation. So that's a big victory for accountability. And it's more than the media's done. I don't know where the Justice Department is on all of this. I think they're going too slow generally on everything I care about, and meaning from Judicial Watch's perspective. And I hope they get up to speed. It's only been a month or so, but still, the Republic's continuing to be under attack. I mean, that charge in Georgia was so abusive and so, in my view, deserving of criminal investigation. And now there are records that I think could reflect on whether a criminal investigation is warranted of Fani Willis's operation. And not only that, whether there should be investigations of what the January 6th committee was up to up here in Washington, D.C., when they were abusing their powers to ferret out information to help prosecutors target their political enemies, namely Donald Trump and other innocents. So another victory for the rule of law today at this court hearing in the Fani Willis matter.
Yeah, so first of all, go follow Judicial Watch on X if you have an X account. So, again, the audacity of the Fulton County DA's office. So, in my view, it is a pattern here of misconduct from the Fulton County DA's office with withholding documentation. We've seen it before. We have seen it before. But this is about to unravel, thanks to the Judicial Watch and others continuing to keep pressure on Fulton County DA's office. It is essential that we keep up, because there's nothing more dangerous to a judicial system than the enemies from within. We can't have corrupt prosecutors. And we've seen a bunch of them, or at least questionable decisions by prosecutors to file, to bring forward a prosecution that should have never seen the light of day in court. That takes time from actual victims, actual defendants, actual suspects who all deserve their day in court. We saw it in the YSL case. We saw it in the Zach Anderson case. We saw it in the Delphi case. We've seen in so many cases where the prosecution brings forward things just because they can. But this seems to, thanks to the continuous pressure that is applied from Judicial Watch, from channels like mine, Cat, and Classy Beats, Sadie Nash, Miss Sylvia, and Miss Bumpus, who's now is Mrs. Jackson. I mean, this kind of pressure needs to be but here's it. We can't only put pressure because, oh, look at this judge, or look at this prosecutor, look at that person, they are all bad. In it, we need to show alternatives. what are the good ones? And in my opinion, we find the good ones in the Adelson case. And we find a good one in, Judge Gaither, Judge, no, not Gaither, Judge Boyd, Judge, yeah, Judge Gaither, and many others. We know that there are good ones. So Fleischer, thank you, Fleischer. Yeah. So we know that there are good ones out there. So I'm somewhat glad. Well, I'm not glad I had pneumonia and was forced to slow down, but it also gave me the opportunity to, okay, besides doing these gavel-to-gavel trials, what else can I do? And I hope to, yeah, the Dinkins case. Yeah, Henry Dinkins case, who was brave enough to find, yeah, you don't have a case here. And just threw it out after the prosecution's case in chief. So there are good ones out there. And so, yeah, but it will be interesting to see what will come out of this, because it's not the only case where Fani Willis is in trouble. And I'm going to keep it up. Dave asked, Nick, can you talk about SEX trafficking in Romania? I already have. I have a bunch of videos on the Andrew Tate case, and some of them are also where I explain the system. So go to my Andrew Tate playlist and you will find stuff about this, how the laws have evolved in Romania, for instance. All right. Now I am very, very curious about this guy, Judge McBurney. I want to see more. And I see here I have random criminal calendars for Monday. Yeah, why not?
Can't work as Clayton Fayette County Jail, yeah.
So Deputy Gordon.
Okay, but before that, we need a swoop. Where's my swoop? There. Yeah, that is my Norwegian fire-fighting dragon swoop. You can't sneak up to that from behind. So, this is Judge McBurney. This is Fulton County. And, well, we have a year and a half or more with of watching the YSL trial. Let's check how another judge in Fulton County does this. Yay! And for you who just showed up, thank you. Thank you for being here. Hit the like and subscribe.
You know we're presiding this week. We are. So if people walk in saying, hey, what's going on? The answer is we're going on all week.
Mhm. But I said, awesome. Okay. I'll find out if they brought him over, if he's still in it.
I don't know if you can. I don't know how they can.
All right, let's get started. We have I think it's labeled an inquiry calendar. We can see what we can do with the cases on there. The first two positions are Mr. Neumeister. He's back.
Yes, Judge. And
We have a negotiated resolution. Miss Nix, I don't, yeah, so I just talked to her. I didn't know she had to be here since it's negotiated. Was going to pad. So we just need to structure our outcome so that it doesn't mess up the plan. His mother will also be logging in. I see her on there. I think it's best though if we don't let him know that she's on. I think she's gonna switch her name over to guest.
Okay, I don't see her.
She's under Sean.
Oh, okay, got it.
Yes.
All right,
So she's in support. She knows what's happening.
good. She and I have met before.
Yes.
So
Ooh. McBurney had a case last week where someone was charged with unaliving a bait was the a bit was the prosecutor and the defendant self-represented. What? Oh, do you know how long it was? Maybe I can. Yeah. Oh, I want to stream that one. Let me just check how long that was.
do we need Ms. Nix, or are you up to speed on Mr. Neumeister?
Judge, I am contacting Ms. Nix.
We're working on it. Excellent. Okay. We'll come back to that when we get Ms. Nix, or she lets one of the other ADAs know what's happening. But talk to me about the pad part, because that can't be a condition of probation. It's reinstating probation, and then we're hoping it goes to pad, or what is it that you and Ms. Nix talked about?
He's linked up with pad.
Mhm.
So I think I submitted a transport order already.
You did?
They're eager to get him this week.
Okay.
Ms. Ross also has linked him up with Grady outpatient services, as well as a safety measure in case something falls through pad.
So we could put in the modification of probation that he continue to work with Grady outpatient services.
Yes,
Okay.
and I don't know if he has a mental health probation officer. I would be requesting one.
He needs one.
Yes, Judge.
Okay.
But my thought was he's been in over a year, so
Yep.
we could just revoke that and then reinstate.
So it's not a Grady Act team, but it is Grady outpatient services.
It is, yes, and I will confirm the name of it with Ms. Ross.
Okay. And what about, I don't remember, I can look back at the sentences, but contact with family, is that still, he needs to, I can say nothing about it, or?
Oh, I think, so we're doing a permanent stay away from the named, so that would be the Diana, I can't remember her last name, and then the therapist. The permanent stay away is not for the family members. I think if we can structure, just remind him to only have contact with them if they want contact.
The family?
Yes.
Yeah. Okay,
Yes. Okay, thank you.
excellent.
I appreciate that.
All right, we will come back to Mr. Neumeister as soon as we figure out about representation for the state. How about Melvin Sampson?
When you're on Michelle Ruff, parliamentary on this case, I believe that there's a bench warrant for him, that's why he's still moving out. And I filed a waiver of arraignment as well. It appears that he was in Clayton County Jail at the time that the bench warrant was issued here. So I am trying to pull those dates up to confirm, and the state has said that they would consent to him being, that bench warrant being recalled.
Once you get that information?
Yes.
Okay, yeah, that was a while ago. It was August 23 that he missed court. So I guess this bench warrant was lurking. He had plea and arraignment on August 11th of 2023. Didn't make it, maybe because he was in jail in Clayton County. I don't know if he was in custody elsewhere, or if this bench warrant just didn't ever catch up with him.
It may have been that it did catch up with him. So because we thought it was the February date.
Okay, I'll look again, but when I was prepping on Friday for today, my note showed that the date he missed was August in 23. This is an old case. His arrest on this original charge is from 21. It got indicted in 23, assigned to me, and he missed plea and arraignment in 23. And I think the bench warrant had been out there. That doesn't mean, I'm not suggesting he's a fugitive. My guess is he didn't, well, if he was in Clayton County Jail, he couldn't have come to court. He also might not have known he had court because of the lag from when he was arrested on the charge to the indictment. He may have changed addresses. And so he may have thought this case went away. Nothing happened for 2 years.
I'm pretty sure it didn't went away.
Okay.
His family hired me on the underlying charges.
Way back when, or just recently? Well, but that's because he got picked up on a warrant.
They thought it was a recent warrant. They didn't know he had court. So I'll get those dates straightened out, and then we'll figure out what we can do. Because
Sure.
It wasn't on the run.
So I'm not suggesting he was on the run, but there's been no activity in the case since August of 23, when I signed the bench warrant. The family became aware of things in February because he got arrested. I don't know why he got arrested, if it was on this warrant or if he had another encounter with law enforcement, but when they ran his name, it would have shown this warrant. So regardless, that's how he got scooped up. But to me, that's consistent with Mr. Sampson not knowing the case was out there. If the family wasn't reaching out to you until February of this year, he wasn't thinking that something from 2021 was still around. So, all right, so do you think you will, let me take one step back. Deputy Gordon, do we have all the folks up now? Okay. Do you think you're getting that information today, or should I bring Mr. Sampson to the door to say, hey, here's what's going on? And we don't need to bring him back. If you can get that documentation, Ms. Dilligard, who will be your ADA on the case, I think, or is it not that kind of aggravated assault?
It's my case.
It's your case. All right. So, if she's satisfied with the paperwork, I just get an email from the two of you saying we're good, and then we'll just reinstate the bond and lift the bench warrant.
So it's what you're telling me, Judge, I don't think that I'll have that paperwork. And I do believe it was that he forgot, so he will need to speak with the court, and also I'll need to speak with the ADA and speak with him.
Oh, because you're not thinking he was in Clayton County Jail way back in August of 2023. Just recently he was in the Clayton County Jail. Okay, that's why he's here. So he got arrested for something in Clayton, unrelated to this, and then they can't let him go because our warrant was here. So you do need to talk to him, figure out why we didn't connect in August of 23. Okay, then we'll circle back after you've had a chance to talk to him, and we can deal with it today. All right. All right, so we'll circle back to that. Check one more thing. Got it. Okay, Antonio Holmes.
I would need to talk to him. I'm sorry, I didn't realize he was going to be mine. So I'm going to talk to him. I'm assuming he missed court at some point. That's why he's making great calendar.
I don't know, let's look. Maybe he can just work his case out. Let's see. Oh, he was in non-complex. And then there was a motion to revoke his bond from the state, but in non-complex. Because he got new charges while he was on bond in that case. It only got transferred here in January. So, because he has another case here. Let's look that one up. 224. Would Jessica Jones be someone from your office?
Yes.
Okay, yeah, so he has a case here. Oh, they're both on the inquiry calendar. Huh, look at that. I'm sorry, position 5. I didn't turn the page. Same guy. And so we have the 23 SC. It's a palm off from non-complex. So I think we could call this plea and arraignment. I don't want to rush you and Mr. Holmes, but the position 5, this is the first time it's appeared on anything. He was indicted at the end of January. So why don't we treat this as plea and arraignment for position 5, and you can, maybe he wasn't able to make bond in this newer case. The bond amount is $25,000 cash from mid-November. So anyway, why don't you chat with him? Let's make sure we do the arraignment or a waiver for position 5. We don't need to do that with 4. It was apparently ready to hit a trial calendar in non-complex, so it'll follow along. All right, Marie Hamilton is not here yet. Who will be working with Ms. Hamilton?
She will be mine, Judge.
All right, so Ms. Hamilton was in drug court with me, and her addiction is very strong. We got her even into an all-female inpatient treatment center, and she walked away from that. Pardon me?
And that's why I'm here. She hasn't been doing
Okay, got it. While she was in jail?
when she walked away.
Okay, that's how, okay, and that's how she got picked up. All right, it's unindicted? Okay.
I can fix that if you want to.
Well, I'll let you and Ms. Wood talk about it. It'd be great to have all our stuff moved together. But this is here because drug court didn't work out. I think she was in drug court on a diversionary basis, so it came back to me. She's been pretty upset about stuff. Have you met with her yet?
Not yet.
Okay. She might not be real warm and fuzzy at the beginning.
Thanks for the heads up.
Sure. All right, so we'll come back to that when she is brought over. She's Miss Hamilton's just coming from the city jail, yes? Okay, great. So we'll see her today. Nathaniel Cargo.
We have a review there who worked out now. I'm going to talk to go over his rates.
Great. Kenneth Jones.
He's mine, Judge. I think we will be able to work his case out today. He's also got a probation matter I'm hoping to handle as well. I should just speak to him.
Okay. All right, and this looks like one that just got slid to us because he's supposedly a repeat offender.
Yes,
Okay. And then Ruben Rainey.
he's also mine, and we should be able to work this out as well.
All right, that's all I have for this morning. So why don't I come back out when we're ready on any one of these? Is that fair?
Yes.
Okay, sir, you are here for one of these cases? Oh, right.
And I'm sorry, I messed up connected for an hour. It's just to try and learn your system on the Zoom documents.
Okay, I'll talk to you in a sec.
Thank you.
And ma'am, I think you're here for Mr. Sampson. Okay, great. And here comes trouble. That is this afternoon, and it was for bond, but his lawyer cheated the system, and he has charges where only a Superior Court judge can hear bond, and he needs to be in the line he's supposed to be in. So I'll be sending an email to that lawyer saying, don't come on down here today. You can keep him up, and I'll explain that to Hutchins. I'll put that in the email, and when that lawyer says, gosh darn, but okay, then I can let him know his lawyer worked very hard and cut in line, but has to get in the appropriate line. Okay. What's going on, Mr. Walker? Did you have something here this morning? Sure, always.
One judge,
Hey,
I don't know if you heard it or not, but I'm here on behalf of Ted Johnson.
yeah, no, I got the email that you and Ricky were helping out. He has one of my older murder cases that he took over for Tanya Miller because she wasn't doing well, and then he stepped in. What's going on?
Judge is pretty tough. Ted, 10 years ago, he had cancer in his kidney, so they took a kid. He went to visit his kids earlier than one.
Okay, did Judge mute? Sometimes judges mute because it is stuff that is outside of the it's outside of what is supposed to be for the public. I don't, yeah. So let me try to skip ahead to when we have
Understanding,
Okay.
but Mr. Leach this morning.
all right. Let's see. Sound came back with this person.
Should he come to the Ms. Wood, you ready to have Mr. Neumeister come out?
Yes.
Great. Should he come to the podium?
Yes.
All right. When Deputy Gordon, maybe you can knock on the door. I don't think he knew we were going to get started back up.
Judge, it doesn't sound like you necessarily need me.
I don't think so. If Ms. Dilligard is happy covering for you, we're happy to have seen you and tasted your baking wares. You are free to roll on to your next stop.
Ask me if something changes.
Okay, sounds good.
Thank
Hey, Mr. Neumeister, if you'll come right up there to the microphone. Good morning.
Good morning.
Good to see you.
It's good to see you as well.
Ms. Ross, are we handling Mr. Leach this morning or this afternoon? Or no?
I could handle him this morning, but I know he's not here for it.
Okay.
here. He's just, I just never.
Oh,
Okay. No, I'm happy either way. I just wasn't sure. I remembered that I didn't get that calendar, or it's not attached to the thing I look at. But you had sent an email about him. We'll do him today at some point, whenever works. All right. Good morning, Ms. Rivers.
Good morning. How are you?
I'm well. Glad to be out of the rain. we're going to go on the record. We have Mr. Neumeister out here. He has two cases, a 17 SC case and a 19 SC case. Mr. Neumeister is here with Ms. Wood, and we have Ms. Nix for the state. Mr. Neumeister, you have been in jail for a long time, as we have collectively, you've been helping. We've all been working together to figure out what's a good setup for you when you're released. And if we rewind for a while, I can remember at one point you were thinking about maybe getting into a school to get some emergency fire suppression training, et cetera. That didn't work out, and I think I understand why. But Ms. Wood and Ms. Ross, you may remember meeting with Ms. Ross, and you have lined up support from PAD. And they will be, assuming we get through everything today, they will be coming to get you on Thursday. I've already signed a transport, well, it's a release order, releasing you to PAD personnel, along with your medications. Don't leave without your medications. And then you and PAD are going to take care of things from there. That's my understanding. But of course, that needs to be what your understanding is and what Ms. Wood is advocating for. But I just wanted to lay the groundwork of what I think we're doing this morning. Okay?
Yes, sir.
All right. So Ms. Wood, my understanding is that Mr. Neumeister is admitting having violated his probation, and we're all acknowledging that he served about a year in custody as a result of that. And yeah, I'll get more precise by clicking a few clicks here. And
Yeah, again, here we are with Fulton County DA's office, probation violation, and he's been in jail for over a year. Now, I don't know what kind of probation violation it is, but a year? Seriously. But this is what happens when Fani Willis and the DA's office decides to put all the money and resources into one trial or two. One trial and one case. Then people will spend years in jail without having a resolution.
And you get 456 days, so a year plus 3 months, so a minute, as they say. But that the consequence of the probation violation would be to revoke a year plus, and then have Mr. Neumeister released to PAD on Thursday. And I'll talk about a few more tweaks that we're going to get in there. And I think I may be signing a permanent stay away order as well. I don't have that paperwork right now, but I want everyone to know what's coming. So why don't you take it from there?
Thank you, Judge. Yes, so we are admitting to the violations. He has been in custody 456 days. We have gone over extensively that permanent stay away order. Ms. Krimovic also went over it with him. He's met with Ms. Ross a number of times. We are excited that PAD is interested in working with him. It's been quite a journey to get to this point. He worked with some Emory doctors and then Dr. Norman, and we feel that he understands and is eager to work with PAD as well. He's also going to be working with Grady's ICM program. I can't remember what ICM stands for, but I talked to him about it in the back, and he is eager to get hooked up with them as well, Judge. So we're asking that you revoke the 456 days and reinstate to probation.
Okay, I will do that. There remaining on the 17 SC case is 1 year and 9 months. If I were to revoke 1 year, I need to revoke enough to get us through Thursday. So let's just say hypothetically, I revoke a year and 3 months, only 6 months remaining on the 17 SC case. My thought was we could just close that one out because there are 5 years remaining on the 19 SC case. So again, if I revoke a year plus, you subtract that out, but that has the much longer probationary tail. And then we're just dealing with one case, which is easier for everyone, I think. I need to hear from the state. They may have a concern about that. But I'm assuming you and Mr. Neumeister would not object if I closed out that oldest case.
That's correct, Judge.
Okay. All right. And you mentioned that there had been discussions about the people from whom Mr. Neumeister needs to forever stay away. That's not family members. And we'll talk about that some this morning as well. I'm just pulling up the other final disposition because the name on one didn't match the name I thought we were talking about.
Is it a last name, Judge? Because I believe it changed.
Oh, maybe that was it. Yeah, because the oldest case is, you need to be careful around family members. The newer case was a Catherine and then a hyphenated last name, but I didn't hear that last name when we were talking earlier.
I believe so. I thought, I don't have it in front of me. You know what I mean? I thought one of them was Diana, or a name that started with.
You mentioned that, but what
Okay.
in the 19 SC case, the requirement was that Mr. Neumeister stay away from Catherine Suzman Schwartz, hyphenated, or her husband.
And that's correct. I think I'm confusing because I went through a lot of the transcripts from previous probation revocations. I think that person might be tied up with the DeKalb County case judge. So I apologize. So, but yes, that's the correct name that you're referencing.
Okay. Now, there were some protective orders out there that are referenced in the older case, but it just says family members or non-family members. It doesn't have names. It just says comply with those. So there could be a Diane, whatever, but the specific name that was in the more recent case is that Catherine Suzman Schwartz. So, okay. Ms. Nix, what are your thoughts about closing out the 17 SC case? So revoking a year plus and then terminating.
Judge, I'm fine with that, as long as the other case does remain open. I would ask that the conditions of that he get a mental health probation officer, and that if it's not already a condition, that he stay on his medication, comply with any aftercare from the ICM program, or compliance with the ICM program, and any aftercare if he does complete that program. And then the permanent protective order, which I will provide to Your Honor here in just a moment. The names that I have are Catherine Suzman Schwartz, Jonathan Schwartz, and Dana Elizabeth Miller. Those are the names that I have.
Okay, got it. That all makes sense. Ms. Simpson, anything you want to add? I know you shared, I think Ms. Nix wasn't here yet, that Mr. Neumeister has had and will continue to have a probation officer attuned to his needs and his situation. Okay, so we'll maintain that. Okay, I think I understand all this. Mr. Neumeister, do you feel like you understand it all?
I understand it right now. Will I be receiving documentation about any of this?
Sure.
Okay.
You will get, well, Ms. Wood will get and can get to you copies. For example, I'm going to be signing 3 orders, it sounds like, today. A revocation order in your oldest case that's going to revoke basically the time you've been in and then close that case out. So you'll see it says terminated. And then in the newer case, which is still an old case, it's going to revoke the time that you've been in, and then it will have those conditions we talked about, and then it reinstates the balance, indicating that you remain on probation. So those are the 2 probation orders. The 3rd order I'm going to be signing is coming from Ms. Nix, the prosecutor, and that's what we call a permanent protective order. And it's me saying in writing, basically, if you forever need to stay away from Ms. Suzman Schwartz, her husband, and whoever that 3rd person is. There is now a temporary one that can expire, or someone could apply to have it go away. The permanent one is the legal system's way of saying they go their way and you go your way. And you can't call them, write them, knock on their door, or anything like that. It just gives them an extra level of comfort. Okay. Those are the 3 things, and you get copies of all those. None of this is secret documents.
Okay, I understand. Permanent protection, I absolutely understand and completely agree, and I'm fine with that. My only concern is that Atlanta can be a small town, and how I know some of these people. I don't know, maybe I'm 36 now, and that won't. I don't think I'd be concerned with that. I don't understand. I'm confused as this revocation. You keep saying revocation. I'm not. I don't understand what you're referring to. Like
I'll try. Let me try to explain, and then we will talk about it more. But I want to touch on the thing that you said. Don't worry about it. Atlanta is big, but it's small. You are not in trouble if you are randomly walking down the street, not in the neighborhood where one of these people lives, and you have no reason to be there. But let's say I feel like McDonald's, and you go to North Druid Hills. There's a McDonald's on North Druid. I'm going to go to one on North Druid Hills, and you walk into that McDonald's, and coincidence of coincidences, Ms. Suzman Schwartz is there. You just need to leave the McDonald's. That's it. Okay. Now, if you stay in your car and watch her get in her car and you follow these active efforts to be in her vicinity, that's a problem. Okay. But the purely random, you go to see a movie and she goes to see the same movie, you just have to go see a different movie.
I accept that. Okay. Yes.
Now, in terms of this revocation, over a year ago, you got arrested because I had signed a warrant saying you were not complying with probation because of X, Y, and Z. I don't have that warrant in front of me, but we've talked about it a few times, and Ms. Wood is saying, no, Mr. Neumeister admits he did those things. And the only reason why we're still talking about this is that we've all been working hard to have a good, well, one, we had to get you stabilized. Because when I first saw you, you had been off the medication and we connected a little bit, but it was pretty clear that you were a little bit out in the wilderness. Yeah. But you've stayed on your medication, things are stable. And so we're able to have this kind of conversation. So we needed to get you stable. And then Ms. Ross and Ms. Wood needed to find a place that you'd be connecting with so that I was comfortable. We weren't just having you hit the streets. Yes. Because your family, on their terms, want to be around you, but you couldn't go stay with them. Yes. And the notion, and you weren't going to go to firefighter school. I needed to have a for sure place you could be. Yes. And that's going to be PAD. Yes. And it's just taken a while because we under-resourced taking care of folks who struggle with mental health. That is a societal ill. We spend a whole lot of money on finding a place for someone who shot someone else in the head. That's called prison. We spend lots on that. We don't spend a lot on finding a way to help keep you on board with your medication and engaging with people in a safe way. And so it takes longer. So all we're doing today is putting that final punctuation mark on you acknowledging I did a year plus ago violate my probation by doing those things. And Ms. Wood on your behalf is saying, nope, Mr. Neumeister admits he did those. That means I revoke some of your probation. When you're on probation, sort of a promise, hey, I'm going to do better than I did before. I had to come into court because I did these things with Ms. Sussman Schwartz. You pled guilty to aggravated stalking. You've been told to stay away. You didn't stay away. There are consequences for that. You got arrested, you got locked up, and you pled guilty. One of the parts of your sentence was probation. Part of that probation was, I'll do these things. When you don't do those things, we revoke probation. It's like, hey, I told you to do it, you didn't do it, so you're going to go to jail for a little while or a long while in your situation. That's the revoke part. It's the consequence for violating your probation.
So, okay, so like when I when I was arrested, that means I was no longer on probation because I was now under arrest, which means now you have to document the fact that that time passed by. And so it has to do with the definition. I'm trying to figure out the definition of the word revoke for your and my purposes.
Sure.
So it's like I get arrested and right.
So you're actually still on probation while you're in custody. That clock is ticking.
Okay.
The good news for someone who wants his probation to end,
yes,
while you're stuck in jail, is that your probation clock is still.
Well, that's not a recommended way to get time to pass on your probation to get arrested. No.
Running. But the revocation is the way we formalize why were you sitting in jail for all that time? Not for giggles, not because we needed to help stabilize you, that's part of it, but primarily because you violated your probation.
Yeah, that's shaking his head. The good news, your probation clock is still ticking. The bad news, you're in jail. Yeah. Oh. And before I forget it, Jack Gotti is still in jail. Remember, Jack Gotti was not guilty on all the counts in the YSL trial. He is still in jail for this bogus probation thing. He's still in jail. It is absolutely mind-boggling. From Fani Willis from the district attorney's office, they are actively punishing him for the jury saying he wasn't guilty. Yeah, Jack Gotti is still in jail because of a supposed prison brawl where the prosecution claimed he was active in. And I remember Judge Whitaker said that in the video she was presented with, she said, I remember this clearly, she said something of the sort, the video you showed me tells me he was not an active participant, rather he was the receiver of violence. And then in a later hearing, we heard the prosecutor say that something of the sort, but he pulled this guy in and became violent with him for hours. And there's something missing here. So yeah, something is absolutely wrong in the Fulton County District Attorney's Office that Jack Gotti is still in jail.
And so then we revoke a piece, and then whatever balance remains, and in the case we're leaving open, when we subtract that year revocation, there'll be about 4 years left of probation. But that clock is running right now while we're talking.
Yes.
And that time is shrinking. But you're going to get out on Thursday. So you'll still have about 4 years of probation left, which gives me some assurance that there's something I can do if, and I'm making this up, but if 6 months from now, you throw a rock through your mom's window because you're upset and you're in a bad space, the police can come, and then you and I have another conversation about, Mr. Neumeister, I thought you were in a better place. And maybe you were, maybe you weren't. So that's how we're moving forward.
So like the title of the document, it's a revocation order, and that's literally to describe the fact that I've been in custody for a year. So that explains what's been taking place for the last year. Okay.
Correct.
Now, will I have another document indicating the remainder of my probation balance?
I don't know that it will be, is the balance shown on the revocation order, Ms. Simpson? No. You can talk with your probation officer and he or she maybe could put something in writing. I'm telling you, and we're making a record right now, our court reporter is virtual, that you'll have about 4 years, you'll have a little less than 4 years left on probation.
Okay, so I'll have some documents indicating why I was here, a permanent protection order, which I'm completely fine with. The PAD program, I'm looking at the housing with the PAD program. Let's say it's one Friday, I'm looking at the documents in my hand and I'm confused. Am I allowed to come back in this courtroom and wait and talk to you directly and
100%.
say?
You are, there's no
okay.
protective order against
Okay,
me. You can come to court. You also can call Ms. Wood. So you have a couple resources. You may even be able to call Ms. Ross. I'm not going to volunteer that up because she's not as frontline as Ms. Wood is, but courtroom AD is your courtroom. It's
Okay.
a public space. And we may be in the middle.
Now, first of all, apparently, I don't know what he looked like or sounded like when he first showed up a year ago for this probation violation. But apparently, now he's under the correct medication. He makes sense. So apparently, this does him good. And he's asking things to understand. And again, the judge saying, sure, this is your courtroom. If you have a question, sit down, wait. In a break, ask to talk to me because you have a question. Or talk to your lawyer or your probation officer. This is the kind of judgeship, if you will. This is good lawyering when they are actively trying to help this guy. Now, the things he supposedly have done, because I have no idea, is some stalking and a protective order against an entire family. So he's still not a good guy. But at least now on medication, he seems to understand the severity of what he has done. Hopefully, he will remain on his medication. Can always hope.
Little something. So you may need to wait a little bit before you and I can have a conversation. But if you're like, hey, wait a minute, why is this happening? You should feel free to come to court. Deputy Gordon and I will work with you. If we don't have the answer, we'll figure out who we need to ask.
Okay, because right now I'm on good terms with my parents, but the arguments tend to revolve around who's going to pay for what. Just
That's
honestly, and so the likelihood that I show up here within a week and just is very high.
Okay.
Only because I'm trying to avoid asking them for money because that creates a series of logistical and conversation. Even asking my mom to put money on my books in the jail becomes an argument because it's constantly what I'm asking her for, and working out anything besides asking her for money would be great because I don't even have a cell phone right now.
Okay.
But I can find the courthouse because I can walk really far in Atlanta, and so
this is a safe place to come.
Okay.
And we can work through things. Now, we're not in a position to give you money, but we certainly, we certainly can work through things. And hopefully you're going to develop some good contacts at PAD,
yes,
where they can connect you with resources as well.
Yes.
Whether it's a way maybe to start working and then you're earning some of your own money so that you can take care of these things. But I also want you to know your family is there and your family cares.
Yeah.
And so there may be friction. What happens with families, but they are very interested in your well-being, and have been plugging into this process all along. Okay.
I don't have any more questions. Okay. So I'm gonna Thursday. You'll probably see me within a week because I think I'll have more questions as soon as I go back in holding tank. So I won't waste your time right now.
Sounds good. Again, start with PAD.
Okay.
When you get out, start with the questions with PAD, and if that's not getting you good answers, like I said, you're welcome to come here 9 to 5, Monday through Friday. We're around.
Okay.
All right, but we're not done. I've answered your questions for now. So what I'm going to do. Ms. Simpson, how do I structure this? I don't want Mr. Neumeister to be released before Thursday, but I also don't want to do the exact math because they may say, oh, we're going to release you. Do I need to revoke beyond Thursday and then there's a transport order, or do I say release to PAD and that will be the indicator? We even know the date, release to PAD on the 13th.
We can do it that way, so that way it's not a condition.
Okay, it's clearly not a condition on PAD. PAD will not get heartburn over that. Okay. Then let me look again at the numbers. 365. 4 months. Okay. Mr. Neumeister, as a result of your admissions that you violated probation in 17 SC 150312, I'm going to revoke 1 year and 4 months You'll get credit for the time you've been in. The only condition on that case will be that you are to be released to PAD on March 13th. That is 3 days from now. No?
Judge, no, I agree with you, but I just remembered I don't want him to get sent to DOC if that's the number we're putting in the order.
Well, I don't think he'd go to DOC between now and Thursday, but I also cannot.
Okay.
I can also not sign the revocation order until tomorrow, and then it's just 2 days. But I don't think it'll move that fast.
Okay.
Good point, because it's more than 6 months. But it's 1 year and 4 months. You'll get credit for time served, and it's released to PAD on Thursday, the 13th. And then I am terminating the balance of that case. So that case is closed once you go to PAD. 19 SC 172-125. I'm revoking 1 year and 4 months. You'll get credit for time served, which is just a little less than 1 year and 4 months. Released to PAD on Thursday, March 13th. It will be a special condition of your probation that you stay on all prescribed medication. If you don't like how a medication is affecting you, talk with a doctor, but don't stop taking it. Say, doc, I need a different version of this medication. And you'll be required to participate in the Grady ICM program. That's outpatient treatment that PAD's going to help connect you with. And that will be the remaining special conditions. There's already in your sentence to stay away from.
Got the question. Isn't that the same judge that refused to set bond for Jack Gotti? Yes, it is. In Judge McBurney's defense, he has to go by what the prosecution tells him. He has to. His hands are tied. But yeah, as Chicken says, district attorney lied about the probation violation. So, and it's still ongoing, sadly. Still ongoing.
Ms. Sussman Schwartz. That doesn't change anything. That was always a condition. I'm adding the stay on the medication and participate in the Grady ICM program and any aftercare. And then finally, I'll be signing this protective order that just makes permanent the stayaways of you from those 3 people. And I'm reinstating your balance on the 19 SC. That's what I told you, where you'll still have a little less than 4 years left on that, so that we have some supervision and you have different supports. You'll have a probation officer, you'll have Grady, you'll have PAD, and of course you've got your family on their terms, but you'll have your family. Okay? Ms. Simpson, anything else you need from me?
Judge, your supervising officer will remain the same to be Officer Cook, based on because she is specializing.
I've never met Officer Cook.
Okay, well, we'll make sure that happens. Should we get a phone number to Mr. Neumeister to?
I wrote
Great.
it down, Judge.
Good. You have a phone number for Officer Cook. That's another one of those things where if you don't know where the probation office is, come here.
Yes.
And then we will connect you with, it's 2 blocks from here.
It's behind ACDC, right?
Yes.
Yeah,
And so you should talk with Pat about how you need to go down there to plug in so that you can meet Officer Cook or however they want to manage that.
Yes.
Okay. So you said you can walk far, and if you can walk here, you can walk to the probation office. Okay. All right. Anything else? Simpson, Ms. Ward, anything else?
No, Your Honor, thank you so much.
Ms. Nix, you'll get that PPO to me.
I sent it to you via email.
Great. It's probably arrived. I've been focused on what we're doing here, but there it is. Great. I'll sign that. You'll get copies of things from Ms. Wood. You can get maybe some from probation. Do you have any other questions, Mr. Neumeister?
No. If I have more questions, I'll make my way here back to this courtroom once I'm not in custody, because I will have more questions, but I won't remember them until tonight when I'm laying in bed. So
Sounds good. Good luck, my friend.
thank you, sir.
Thank you, Judge.
Yeah.
Mr. Johnson? One of you is Mr. Johnson?
Yeah. Now, again, this guy been in jail for a year and 4 months for a probation violation, which I assume has something to do with stalking. But a year and 4 months in jail? When apparently he would have made, as the judge explained, he would have done approximately that time in that case anyways. So they just, let's clear that off your docket, and now he only has this other one where he has just under 4 years left of probation, where he apparently, in my interpretation, stalked an entire family. Hopefully he will stay on medication. Yeah, year and 4 months was without any court hearing. Yeah, but welcome to Fulton County, where they spend the money on, where Fani Willis allegedly spends the money, rather spend the money on her boyfriend or on crap RICO. All right, let's see what the next case is.
It's Ms. Johnson. I'm sorry, it's covered up. Ms. Johnson. Yes. Yeah, probably Mr. Johnson's not here. All right. I'm gonna sign this and get you on your way. You bet.
I really enjoy this day-to-day court, but it also reveals what's going on in Fulton County. I mean, you should never be in jail for a
How do you
year
pronounce
and
your
4
first name?
months for a probation
I
violation.
like the first name.
Without a hearing. They had the initial hearing where they
And
said,
your
well, you have to wait
employer
in
is,
jail.
what do they do? Is that a law
And
firm?
then over a year later.
Cases.
Are you a paralegal there or an attorney there or you? Okay. How long have you worked there?
Over a year.
Okay. All right. So I've signed this. All it means, you still have to go file things. It just means you don't have to pay the filing fee. Okay. Good luck with that. Sorry for the confusion. I didn't mean to call you Mr. Johnson. Your name was covered up by your license.
Okay, thank you.
Take care.
All right, what's next?
I'm ready for Mr. Sampson if you are. Okay.
Mr.
If you want to come up to
Sampson.
the podium, we'll bring him out.
Mr. Sampson, what allegedly are you there for? Probation violation, that would have probable cause. I mean, that would have been the first hearing where the judge heard about the that's more or less a bond hearing, more or less, where the judge determined is there probable cause. So that was a year and 4 months ago there was a hearing, and since then he's been in jail.
Good morning, Mr. Sampson.
Good morning, Your Honor.
How are you?
I'm doing well.
Good. Mr. Sampson, I'm Judge McBurney, and your case was assigned to me a long time ago. You had court in August of 2023. And Ms.
Wow.
I signed a bench warrant back.
Wow. Okay. August of 2023.
Then, and I guess that bench warrant just kind of lingered out there. And then you had something happen in Clayton County recently. And that bench warrant caught up with you. You got transferred here. And we need to talk a little bit about why you missed court in August of 2023, why I shouldn't be worried.
Okay. So he didn't come to court in August of 2023. And then it caught up with him in Clayton County, a neighboring county to Fulton County.
About you missing court again, because your lawyer would like you to be back on your bond, and we'll go from there. Okay, so I'm going to hear from Ms. Ruff. I may hear from Ms. Dilligard as well as the prosecutor who has your case, and we'll figure out what we're going to do. Ms. Ruff.
Good morning, Your Honor. Thank you. I am asking that Mr. Sampson be returned to his bond. He did not know about the court date. He was incarcerated from December 2022 to June 2023. We're not sure of the exact dates at this point. I can get those. Do you want to explain why you were?
It was for a DUI and a fleeing and eluding charge.
In what jurisdiction?
In Cobb County.
In Cobb. So basically Christmas time of 22 all the way through June of 23?
Yes, sir.
And it was low. You didn't go into the state system. You were in the Cobb County jail the whole time?
Yes, sir.
Okay. And was that because you were serving a sentence or?
Yes, I was serving.
Okay. Got it. And is that sentence over or are you still on probation?
I'm still on probation.
Okay. Is it felony probation or misdemeanor?
Misdemeanor.
All right.
Yeah.
Out of Cobb or for something else? For a different case?
It is for 22-9-2636. And that case has expired until December 2027.
Does it list the charges?
And he also has a probation on that case.
Okay. Do you have more than one case out of Cobb or we're talking about the same thing?
It's two. It's misdemeanor probation and it's felony probation.
All one case. So like the fleeing and attempting to elude would be a felony.
Right.
Okay. And you're on probation for that.
Yes, sir.
Okay. But you got out in June.
Yes, sir.
All right. Let's keep going with the timeline because then we were going to meet in August, but it didn't happen.
So at that time, he was, and at the time of his arrest, he was still with his child's mother. He has one child, and they were living in Canton, Georgia, at 600 Preston Circle, Canton, Georgia. So he believes that the notice for this arrest and this case would have possibly gone to that 600 Preston Circle. But that child's mother had moved in with her mother, and he was in jail, so he moved, and he was living with his sister and grandmother for a very short time. Well, his grandmother had stated that she had received a call from the DA here in ADA, and they had said the charges were dropped. I haven't been able to go online. I don't know if they were actually dropped. I don't know. We don't know any of that. That's just what his impression was that he was no longer facing those charges since it was from 2021. He has moved in with his partner, Kayla, and they live at 950 Lake Ridge Parkway in Riverdale. We think that it would be safe to send any notices and keep his grandmother's address as his permanent address. She's raised him since he was 11 years old. His father is deceased. His mother is in Boston, but they do not have any contact. And his grandmother, as I said, raised him and his sister. His niece and nephew also live there. So he would, upon release, go back with Kayla, but then again, his address, and then now I'm involved in the case. So I would also be notifying him of any notices, and I have a lot of contact with Kayla, so that would continue as well.
What's Kayla's last name?
I'm sorry, Kayla.
Davis?
Yes.
All right. But you don't think, Ms. Ruff, we should use Ms. Davis's address as the address in the system for notices for Mr. Sampson?
No, I think it's safer to use his grandmother's address. She's been at this address.
Are you planning on moving, Ms. Davis? You are. Okay. Moving locally?
I would say for the north in the area.
But not to like Kentucky.
No, of course not, in Georgia.
In Georgia. Okay. All right. And why are you moving?
I just don't like the apartment to make it too stressful.
Okay. You don't like where you are, but got it. Okay. Does further north mean all the way up to like the border, or further north means going to Johns Creek or? Okay. Got it. Okay. Understood. What's that 729 Fitzgerald Place?
That's grandmother.
Do you not know that address, Mr. Sampson?
Oh, no, I know it.
You know it. Okay. I was asking you, what's that 729 Fitzgerald Place?
Oh, it's my grandmother's house.
Okay. That's the good address?
Yeah.
Okay. All right.
I had the house since 2008.
Who else lives there besides your grandmother?
My sister and her 2 kids.
Does your grandmother work?
Yeah, she works at Amazon.
And does your sister work?
Yeah, she works at Kennestone.
What about you?
Yeah, I work at in the battery, I have Battle and Brew. I'm a cook there.
Okay. So you've been in about a month.
So he's been jailed because a faulty address. Well, faulty address is, you have to tell, if you have something out there, tell them the new address. But here it seems like, according to the grandmother, the charges was dropped. But well, it's a weird circumstances here where he seems to have believed that whatever that other case was, no longer. And all of a sudden, about a month ago, that bench warrant, which the DA's office applied for in August of 2023, all of a sudden, boom. And so now he's been in jail for a month.
Will that job still be there at Battle and Brew?
Yes, I talked to my chef. He says upon my release, I'm gonna still have a job there.
Okay. And how are you getting from Riverdale way up to the Battery?
Drives me or Uber.
Why do you drive him everywhere? Does he not have his own car? No. Do you have a valid driver's license?
No, it's suspended.
I'm sure you do, Ms. Davis. I'm not worried. So that's part of that Cobb thing. You're not supposed to be driving?
Yeah.
Okay. And it's good that Ms. Davis drives you around. So your notice back in July of 23 went to that Preston Glen Circle in Canton. So that's why you didn't get it.
Yes, Your Honor.
Got it. Okay. That makes sense. Your bond in this case, assuming it's still, you haven't done anything wrong, it's just an old bond, and bonding companies sometimes kind of walk away from things, but your bond is from July of 21. And the only big condition is that you're supposed to stay away from Taekwon Gerald Bly. Do you know who that is?
Yes, he's my cousin.
Okay. Have you been staying away from him?
Yes, we haven't had any contact.
Okay. I mean, just sometimes when it's relatives, that's tricky because, hey, I'm going to my grandmother's house. My cousin's going to be there and I can't be around him.
No, I haven't seen him since.
Since whatever happened. Okay. Keep it that way. So you've done a waiver of arraignment, Ms. Ruff. And so I think all we need to do is I will set aside the bench warrant, which will release Mr. Sampson. And the address in the system is good. We don't need to update it. That's grandmother's place. And as long as you have good contact information, you're in the system. So as long as you have good contact information for Mr. Sampson, it sounds like you do through Ms. Davis, then if he misses court again, it's on him because he's got a big network of people telling him you need to come to court. Grandma, significant other, lawyer. You waived arraignment. Let me see what that looks like. Okay, and you've opted in discovery. So we'll enter a scheduling order this week, which gives the state, Ms. Dilligard, a deadline to get you discovery. Your motion's deadline is tied to that, so you haven't missed any deadlines yet. That scheduling order, so here's when the state gets the defense discovery, here's the deadline for defense motions, if any, and then there's a final plea date. Mr. Sampson, I won't see you again until we either have to argue a motion, it may be, and I'm making this up, but the police interviewed you and your lawyer thinks that they interviewed you in the wrong way and she wants to suppress that interview. But if there's nothing like that, then I'll see you for what we call final plea, which is the last time you could resolve your case by entering a plea and withdraw that plea if you don't like the sentence you get. Most cases are negotiated anyway, so you don't need to worry about that. And this may not be a case where you're pleading. You may want to go to trial. And that's what we would do if nothing happens at that final plea. Your main thing is to stay out of trouble. You are on probation and you've used up your free pass here by missing court way back in August of 2023. So just make sure you don't get pulled over driving when you're not supposed to be driving or anything like that. And I will see you at the next court date. Ms. Dilligard, anything from the state? Ms. Ruff, anything else on behalf of Mr. Sampson?
No, Your Honor.
Mr. Sampson, any questions about anything we've discussed?
No, Your Honor.
Okay. Thank you, Ms. Davis, for being here. All right, you're good to go. So you will get out. If you don't get out, you're wearing orange. Are you being held at Cobb?
Yes, I'm being housed at Cobb, but
Okay.
I'm still informed.
No, I understand. We have some excess capacity up there. If you're not released today, it should be tomorrow. If you're going to bed tomorrow night at the Cobb County Jail, call your lawyer so she can figure out what we haven't done on our end.
Okay, thank you, Your Honor.
All right.
Thank you. This is all. May I be excused?
Yes, ma'am.
All right, thank you.
All right, so it seems to be working out for Mr. Sampson. And I'm glad for him. It seems like he has been a productive citizen since he got out in June of 2023. It's just this bench warrant that wasn't sent to the correct address. So he will be out today. By the time we are watching this, he should be out and back to work. And first of all, for you who don't know, I get YouTube allows me to gift 10 free memberships per month. I gifted one a week and a half ago, and I gifted 5 more now. And it went to Rhonda Hall, Ariane the Vegetarian, Lisa Fortlesack, Rachel Hope, and RX Tech 2. And then Dave gifted 5 memberships. Thank you. Thank you so much to Coach Karen, Big Dog, XX Name XX, Fire and Ice, and Laura Jane Thompson. You also was gifted memberships. So that means that you now have access to all the members-only content. You have access to your own emojis here on YouTube, and you have... I will put in a link to my Discord for members only. So thank you so much, Dave. And so 10 new members today. That is nice. That is nice. All right, that was Sampson. And let's keep going. Let's see who the next one is.
A bond hearing, so there was a bond hearing filed, and if you're I would be inclined to hear bonds, you said, like.
In which case?
The aggravated assault case, that's the only one that's. And so it was a bond, motion filed in November, so I told him I would file one, he was set to waiting since November when it previously filed for him.
There was a petition to reduce bond filed in November. That's the thing you're relying on as the motion?
Yeah.
Okay, got it. You've done a waiver and an entry, so we'll get that taken care of. Ms. Charles, is this your case?
Yes, Your Honor.
Are you comfortable talking about bond?
Your Honor, the state position would be that Mr. Holmes already has a reasonable bond set. And as far as the conditions that were present in November, the state there's been no material change. It's And we ask that you, you know.
Okay.
As is.
Well, why don't we, I hear you on that. So two things. One, we'll bring Mr. Holmes out. We can hear that. I may end up agreeing with Ms. Charles. And because you may not have known we'd be talking about bond today, you may want to reach out to Ms. Hunter. So I won't make any, if I was inclined to change anything about the bond, I would condition that on you having an opportunity to reach Ms. Hunter so that her input could be shared with everyone. Great. All right. And what about the older case? That's just going to follow along with the newer case? All right. So we'll get a scheduling order for the newer case. Do you have discovery for the older case? Would that have come to you through the non-complex lawyer?
No, the non-complex lawyer to see if he could send it, but I don't know what's going on. I don't know if he's got it. Sometimes there's issues with non-complex. I don't know.
Right. So I guess this will be split in the DA's office because Ms. Dilligard, you'll handle the drug case and Ms. Charles will, but if it's a universal resolution, one of you can do that. Okay. All right. We're ready for Mr. Holmes, please.
Mr. Holmes, let's see what this is all about. Dun, dun, dun. Here
One
is
second.
Mr. Holmes.
All right. Mr. Holmes.
Yes, I do.
I'm Judge McBurney. Nice to meet you. Your case 25 SC 000224 has been assigned to me. And that means that you had an older case in non-complex that has been sent here as well, so that all your cases are in one place. Ms. Rios will be handling both those cases for you, and I'll be presiding over them. Your lawyer on the more serious case, you're charged with shooting at someone. That case, I'm gonna call it the assault case. It's just an allegation, but that's the allegation. Your lawyer that you had before it was indicted filed a motion to reconsider bond. You were given a bond by Judge Brooks in November of last year. And I guess it's too much. You haven't been able to make it, meaning post that bond. But Ms. Rios is going to talk to me a little bit about that. I'll hear from Ms. Charles, who's the lawyer who is the prosecutor on your assault case. And then I'll let you know what we're going to do. Ms. Rios told me you already have a bond in your older case, the marijuana case. Is that correct?
Yes.
Okay. All right. So we're going to have that conversation. And regardless of what happens today, things will start moving a little faster. Ms. Rios has filed her entry and waived arraignment on your behalf. So she'll start getting the discovery in the two cases so she can meet with you to talk about what kind of evidence the state has. And if there are issues that she thinks she needs to file motions about, she'll do that and we'll work through those. Okay. All right, Ms. Rios.
Yes, Your Honor. Mr. Holmes is 50 years old. He's from Atlanta. He has 11 children ranging in ages from 27 to 2. Before he was incarcerated.
He has 11 children from ages 27 to 2. I don't think that is by the same mother, but by the same woman. Oh, he is a hero of Elon Musk, who claims we need to produce more children.
He was working at Apply in industrial technology as a forklift operator and material handler. I'm asking for the bond to be reduced to no more than $5,000. That way we can go, and I know that's a low bond, but that way we can go through the bonding on the bill project. So hopefully he can get out and start working and taking care of all the children that he has. I don't know, I haven't looked into too much of the case since I just got it today, but it seems like it wasn't a situation where not going too much of the facts that a gun went off. It seems like it was the situation and there were other people around, but it wasn't a situation where I know based on the charges, that to make sure it's not like the understanding that he just pointed the gun and shot at someone. So based on that understanding of the facts of the case and the fact that he's been in 5 months and he has a job he can go back to, I'm asking for the $5,000 bond.
And if Mr. Holmes is able to make bond, whether it is the current bond or a reduced bond, where would he be staying?
The address that's in the system, the 2808 Torham Court. He lives there with his brother and his brother's wife.
Okay, and that's
okay. So 11 kids, and he lives with his brother and his brothers. Yeah. So 11 kids and not living with the mother or mothers.
Not where Miss Hunter is?
No, no.
He
Okay. Is
needs
Miss
a
Hunter
new home
the
again.
mother of any of your children?
Yes,
How many?
this is my 2-year-old.
Your youngest?
My youngest son.
Okay, got it. Another address I have associated with you is on McDaniel Street, 585 McDaniel Street.
Old address, yes.
Okay, is that where Miss Hunter lives?
Oh, no,
Okay, so she doesn't live there and she doesn't live at this Torun Court.
she does not.
Okay. All right. I think I understand all that. Ms. Charles, I know you are being called upon without a whole lot of notice that we'd be talking about bond, so I'll keep that in mind as you're sharing with me your thoughts about what ought to happen here. And it should be clear on the record, Mr. Holmes has bond. It's not that he's in a no bond status. He's had bond for a number of months, which says to me that's a bond he can't make. Judge Brooks may have felt that it was reasonable both for what she heard in the case, but also because of his financial situation, because he was working. Financially, it seems not to be a practical bond. That doesn't make it an impractical bond. It's just not one that Mr. Holmes can post at this time. With that said, what do you want to add?
Yes, Your Honor, just briefly on the Parsons case. On October 30th, 2024, when Mr. Holmes entered the home of one of his children, Jasmine Hunter, he was intoxicated, and according to Ms. Hunter, he began to whip her firearm around, accusing her of being unfaithful to her, and during the course of assaulting her, there was one round discharged from the gun. There were children present who also observed what was going on. And I would say, notably, although Mr. Holmes did not have a significant felony criminal conviction history, at the time of the October incident, he was out on probation for a June 7th, 2024 incident for which he pled guilty on January 13th of 2025. In that case, 24 CR 003-557D in state court, he had been charged with criminal trespass to property against Ms. Hunter, was also the victim. In that case, he had broken out the windows of a home. And so there may.
If the allegations are correct, $5,000 bond. So allegedly, he was drunk or intoxicated, broke into the baby mama's home, waving a gun around, and a gunshot went off in a home where there were children. Yeah, Mr. Holmes, I don't care about you. If this allegation, now again, innocent until proven guilty. But this is kind of serious. This is very serious. In my opinion, that bond should go up.
Again, while there may be some indications that they do have to do together, and I will say, based on the note, my review of the notes of this case, in October of 2024, Ms. Hunter did not deny the allegations in the indictment. She did want to continue to have some contact with him as far as co-parenting the children, but nothing further. And I don't anticipate that to have changed since November of last year.
Okay.
And Your Honor, just received a note from
Miss Baby Mama. So you have more than one child with this man. He went into your home, a gunshot went off, and you want him around your kids? Why? Why? There's got to be better men out there in Atlanta. There's got to be better men out there.
He did regard that there may be also be a pending motion to revoke his bond in the drug case. And so all that being said, Your Honor, I believe that the bond that he has is a reasonable bond. Bond is not entirely punitive, but not also just one that he can afford. It just has to be reasonable. I believe in the totality of the circumstances, it's reasonable, and we have to keep it in place.
And they're not asking for a
Thank you for reminding me on the
bond.
motion to revoke bond. It didn't get heard, but Brad Malkin, who is one of the non-complex unit prosecutors, in January of this year, filed a motion to revoke Mr. Holmes's bond in the drug case. And it would assume it would be the newer bond as well, for his guilty plea to criminal trespass in the state court case you just mentioned. So we've got things pulling in opposite directions. Ms. Rio saying lower the bond so Bail Project can help out, and Ms. Delegard's predecessor on the drug case saying got to revoke the bond in the drug case. Do you want to talk about that? That wasn't on the calendar either, to talk about the motion to revoke bond. So I'm happy not moving forward with it today, but it's there.
Yes, if we can do that another day.
Okay.
Let me get the files now.
Got it. Right. Okay. Mr. Holmes, anything you want to add? I don't want you to talk about the facts of your case. I'm not asking you to say, oh, that's not how it went down. That's not what today is about. Or you feel like Ms. Rios has covered it?
Yes, just it's not as extreme as I would say. It's
okay, but that's you talking about the case. Don't do that.
I'm saying it's I have a lot of responsibilities. Just about it. I'm not that monster, should I say, but I have a lot of responsibilities. I understand the situation, but I do have a lot of responsibilities. My kids.
That's what happens when you have 11 kids.
I lost my car, close to losing my home. So I just when I did have it, took care of my kids. You know, it's where I'm.
I don't care. You have a lot of responsibilities. Well, you and the rest of the world. 99.99999% of the world with a lot of responsibilities do not break and enter, wave a gun around amongst kids, and then a gunshot goes off. Here, I think they are too lenient. Here, now the October of 2024, I can't feel sorry for this guy. If the allegations are correct, and it seems like, without listening to him explaining too much, it seems like they are correct. I don't have sympathy for this guy at all. There's a lot of people out there with a lot of responsibilities. You chose to father a bunch of kids, ages 2 to 27. And it seems like you chose to abandon them all. You have no sympathy from me, Mr. Holmes. Absolutely zero. Now, apparently, one previous prosecutor says revoke bond, one says keep the bond, and his attorney wants to lower the bond. I don't want him on the streets. What happens next time he is under stress, decides to drink? Yeah. I must say, but that other thing was not, that was revoked bond for a marijuana case. I don't care about that at all. In my opinion, big portions of the world are decriminalization of weed. I think that is the correct way to go. But waving a gun around with your ex around your kids, yeah, screw you, guy. Screw you.
I'm incarcerated, but
okay,
it's running thin.
Okay,
not a bother to no one.
All right. So here's what we're going to do. I need to give Ms. Charles an opportunity to reach out to Ms. Hunter to see if her perspective has changed sometimes. In a situation like this, what you might hear is that Ms. Hunter would like to see a lower bond, i.e. one that Mr. Holmes can make so that he can get out and start earning again and contribute more meaningfully to the upkeep of their shared child. But Ms. Hunter may want to balance that with the peace of mind she's had while Mr. Holmes hasn't been able to break the windows at her place, something he's admitted to, not even talking about the gunshot. And Ms. Hunter doesn't make the final decision, but I think her input is important. And so I'm going to give you an opportunity to do that. And then we ought to reconvene so we can talk about the state's half of the equation, which is the bond in the drug case should be revoked because of Mr. Holmes's new conviction out of state court. I need to give that a fair hearing as well. So Mr. Holmes, I'm not changing anything right now. I'm not changing it in your mind for the good by lowering your bond. I'm not changing it in your mind for the worse by revoking your bond in your drug case, because that would make the bond in the assault case immaterial. You wouldn't be able to get out anyway. I need to give Ms. Rios a chance to look into the drug case, understand that a little bit more. I need to give Ms. Charles a chance to talk to Ms. Hunter. I don't know if while you've been in custody, you've been trying to talk to Ms. Hunter on the phone. That would be a bad choice. Don't change whatever radio silence you've maintained, assuming you've maintained radio silence, okay? All right, Ms. Rios, anything else on behalf of Mr. Holmes? We'll get a scheduling order in place on the assault case, and then we can reconvene. You and Ms. Charles can just talk to Ms. Nelson about when we want to get back in touch. And Mr. Holmes, we don't need to wait weeks and weeks to do this. The one thing you need to be comfortable with, assuming you are, is it maybe the quickest way to get you back in here is going to be on a screen. We have these booths at the jail where you zoom in, and because I can't bring inmates over every day. So it may be that Ms. Rios and Ms. Charles talk and say, hey, we could have the next conversation about bond on date X. But that's one where we'd have to get you on a screen. As long as you and Ms. Rios should talk about that, but as long as you're all right with that, that might be how we have the second part of the conversation. Okay?
Yes.
All right. Thank you.
Thank you.
Now, in this supposedly assault case, this prosecutor says, hey, keep the bond. Remember, this is the same district attorney's office that went up to this judge and said about Jack Gotti, no bond. And he revoked bond. So it seems like this judge is listening to what the prosecution says. In this case, this prosecutor wanted no lower, no higher, the same bond, $5,000. And he goes with it. And in the Jack Gotti case, the prosecution told him, we want bond revoked. He revoked bond. I don't get this to add up, other than judge is going by the prosecution's recommendation. There are those. I mean, he has a lot of liberties to do whatever he wants. And in the Jack Gotti case, I mean, it was a prison brawl or jail brawl, which we have two different versions of. And Jack Gotti is still in jail. I need to see more about this judge to see how much he actually do what the prosecution says, because even though he seems fair, it seems to be conditioned on what the prosecution tells him. Is he really fair then, or is he just a tool then? All right. We have time for one
Ms.
more.
Hamilton.
We have time for one more case of this.
So Ms. Hamilton, is she here yet? Ms. Hamilton? Okay, we'll check. Let's push through a few others and see where we get. Are you ready on Mr. Cargo?
Yes.
All right.
No, I didn't hear.
Oh, we can do a different order if you want.
He has put Judge Jones.
Yes.
I had said this would be a plea, it turns out it's not actually going to be a plea today, Judge. So if we could just put this, I think Ms. Nelson had raised my request to be on inquiry calendar. We would just want to go ahead and throw a trial calendar. Turns out he does want to work with Ms. Ross to see if she can.
He does?
Yes.
Okay. If it was a plea today, he wasn't going to work with Ms. I mean, how is that going to?
He has changed his mind a couple times. Judge.
Okay.
And so he would like to speak with her now.
Okay, just give me one sec. Oh, so he's been in close to a year anyway. So it could have been a plea anyway, but he wants to work. I'm all for getting him plugged in with the program. So you're okay. You did your waiver of arraignment pretty recently, but if we kind of fast track it onto a trial calendar, you're all right with that? Does that work for you, Ms. Dilligard? You don't have to say yes. Okay. All right. We'll do that. Then is Ruben Rainey going to be a revocation? All right, then why don't we bring Mr. Cargo out, please? Yes, ma'am. Good seeing you. Cargo, how are you? You're on that. There you go. Give me 1 second.
Okay, what allegedly did this guy do?
Okay.
Oh. Oh, is this the self-defense? Oh, here's the this guy is apparently defending himself. This is from the this is a different guy from the March 4th docket. Let's see here. No, I think these are different guys. Well, we will find out sooner or later. Let's see. Because
Mr. Cargo, my understanding is you're prepared to enter a plea in your case. Is that right?
Yes, sir.
Okay, let's get everything going. All right, Mr. Cargo, for that to work, Ms. Dilligard, who's seated behind you, but you can see her on the screen, she will be putting you under oath, asking you a bunch of questions. You're familiar with the kinds of questions she'll be asking, and you just need to make sure you answer those truthfully. If at any point you've got a question of your own, let Ms. Rios or me know, okay?
Okay.
All right, and we'll see how this goes. And this is a plea to misdemeanor or misdemeanors, is that correct?
Yes.
Okay, all right.
Typing up the.
I am ready when you are, Ms. Dilligard.
Mr. Cargo, can you please raise your right hand to the your ability? Do you swear or affirm that statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true and correct legal name for the record.
Daniel Benjamin Culver.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Yeah, Zyprexa and Trileptal.
What do you take those medications for?
Bipolar schizophrenia.
Okay. How long have you been taking those while you've been at the jail?
The whole time.
Whole time. Great. When do you take them during the day?
Once in the morning, once in the evening.
Did you get?
Okay, yeah, this is definitely not the guy who is self-representing, because with those conditions, bipolar and schizophrenia, I don't think that would be a successful plea for him to represent himself.
Get it this morning?
Yes, sir.
Good. Are you feeling like you understand what's going on in court today?
Yes, sir.
And the medication helps you understand what's going on?
Yes, sir.
Good. All right. Thank you.
Mr. Cargo, how old are you and how far have you gone in school?
I'm 34. I didn't graduate. That's it.
How far did you go in high school?
12th grade.
12th grade. So you got close, but didn't graduate.
Yes, sir.
Do you understand that you have been charged with the following offenses? Been charged with felony obstruction of law enforcement officers, a simple battery against a police officer, and public indecency?
Yes, ma'am.
Yeah, that bipolar and schizophrenia makes you do stupid things. And on medication, he is capable to understand. Without, as he probably was. So, okay, so he fought cops naked, apparently. Yeah, I don't want to see that situation.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances related to those charges?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any all defects in the indictment for purposes of the plea?
Yes.
Mr. Cargo, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you are pleading guilty to today?
Yes, ma'am.
Just go over that really fast with you. One moment. For the simple battery and the public indecency, the range is 1 to 12 months. And for the willful obstruction, one moment, just double checking.
Yes.
It's 1 to 5 years. Is that your understanding?
Yes, ma'am.
Oh, well, as charged, the felony obstruction is 1 to 5, and I'm reducing that to a misdemeanor obstruction. The range is 1 to 12 months.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to reduce the felony obstruction to misdemeanor obstruction for and for count 1 would be 8 months to serve. And on counts 2 and 3, it'd be 12 months probation to run consecutive to count 1. And the conditions of probation is for the defendant to receive a mental health evaluation and to comply with any treatment as prescribed from there. And then also 40 hours of community service.
Are the two 12-month terms, I know they're consecutive to the 8 months to serve, are they concurrent with each other?
They're concurrent with each other, Judge.
Got it.
Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court's not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
And do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to run those sentences consecutively to each other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the plea you were expecting today, that you have the right to withdraw your guilty plea?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea?
Yes, ma'am.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
You understand that if you're on probation, you must follow all of the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial.
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Yes, ma'am. No, ma'am. No, ma'am. No.
Mr. Cargo, how do you plead to the reduced charge of misdemeanor willful obstruction, simple battery against a police officer, and 1 count of public indecency in indictment number 24 SC 003885?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the evidence would show that on June 19th of 2024, officers was driving a marked unit into work, observed the defendant not walking in their crosswalk, but instead in the intersection in front of the precinct. Officers told him to get out of the street, and the defendant pulled down his pants and underwear, revealing his buttocks and private areas. Officers got out of their car to detain the defendant, but the defendant swung his fist at the officer. The officer ducked and had to use his taser to obtain.
Oh, thank God he said he swung his fists at the cops.
In compliance of the defendant. And all of that occurred in Fulton County, Georgia, Judge.
All right. Thank you. Good morning, Ms. Jackson. She's not in court. She's on the screen. I'm not talking to an imaginary person.
Oh, that's a bad joke in front of a schizophrenic.
Ms. Jackson, are you able to hear us?
Good morning, Your Honor. I was sorry, I was having problems unmuting and turning on the camera.
No problem. Thank you for joining us. Could you share criminal history information on Mr. Cardbo, please?
Yes, sir. He has 50 cycles. The last arrest was June the 29th, 2023, with the Marta Police Department for possession of cocaine and possession and use of drug-related objects. Those charges were.
Okay, so this again, we are all supposed to be responsible for our own actions, but this guy, bipolar and schizophrenic, 50 cycles at 34. This is one of these guys that would do much, much better at a facility, even an open facility, as long as he gets his medication. But it seems like he self-medicates and crap happens. Hello, Mr. Jingles. Hello, Mr. Jingles. Everybody, Mr. Jingles is here. Oh. Mr. Jingles is the actual owner of this channel, but you all know that. You all know that. Yeah. With mental illnesses, crap happens if you're not medicated, not on the correct medication. So it seems like he is coherent here in court once he takes his medication. But once out, who controls that? So yeah, even an open facility, in my opinion, would have been but there are so few of those. There are so very, very few of those. Maybe the world will be a better place, because this, folks, this is not unique for the United States. It happens everywhere. It happens everywhere. So, but how do we solve it with mental health things?
Were dismissed on September the 7th, 2023. He does have a prior felony conviction and a sentence. Sworn in 2023 for felony obstruction of an officer. He received first offender treatment in 2016 for felony obstruction of an officer. That case was sealed October the 18th, 2022. He does have misdemeanor convictions. Sworn in 2019 for giving false information to an officer, and one in 2018 for simple battery. And there was one in 2014 out of New York for disorderly conduct. So additional one in 2014 for theft by shoplifting. And there was another one in 2014 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Ms. Jackson, did you say that those, at least one of those misdemeanors from 2014 was from New York?
Yes, sir.
Got it. Thank you. Ms. Rios.
Yes, Mr. Carbo is 34 years old. He's from Georgia, lived here the majority of his life. He does not have any children. He has been stable on his medication since he's been in the jail. I did initially try to do behavioral health court, but he has a warrant out of Jonesboro, so he cannot go there. So what me and Ms. Ross came up with was that when he is released from Jonesboro, go get services for Pat. I have the address written down for him to go there. And for when he gets released, he'll have to go to misdemeanor probation, show up in person because he doesn't have any address or contact information. I'm also asking for his probation fees to be waived based on him not being able to, I'm not sure if he'll be able to work or have an income in the near future. And I think he's doing much better now, since I know initially had some concerns. He's found that he's fine and he's been on his medication, and talking to him recently, he's been very much so coherent, understanding everything I'm saying, and we've been able to have meaningful discussions.
So thank you for all that. BHTC said yes, but because of the hold from Jonesboro, or does it depend what the hold was? Because we have gotten people into one of the accountability courts conditionally, and then they had to go deal with a hold elsewhere. And we put a hold on them once they're gone that says bring back. And when you come back, you start your participation in whichever one of the courts it is.
Well, they said that before they could even go forward to further screening, that hole needs to be figured out. That's what the email from.
I believe you. That's not a consistent answer because we have had scenarios where, all right, he's got to go to Cobb to deal with what's going on. It's not a murder hold, but it's a hold for another thing, a shoplifting or a.
Yeah, I actually had a case just like that, and they went and I think they're still there in Gwinnett County, so I'm not sure.
Okay, I'll chat with, not about Mr. Cardbo in particular, but just see why we don't have a consistent approach to that. Because given the number of cycles Mr. Cardbo has, and for what, it sure seems like BHTC would be great. This sentence will get an evaluation-ish, but I've not ever seen those turn into a particularly robust treatment program, but we work with what we have. And he's got to go to Jonesboro anyway.
Yeah.
So, okay. Thank you for sharing that. Mr. Cardbo, any questions about anything we talked about?
No, sir.
Okay. What do you have down in Jonesboro? Do you know what they want you for?
No.
Okay. Ms. Jackson mentioned some trouble you had up in New York. Did you used to live in New York? What were you doing up there?
Yeah, I got family out there.
Okay. Were you visiting family or did you live there for a while?
I was out there just visiting.
Okay. Home is Georgia for you?
Yeah.
When you get out, do you have a place to stay or will Pad be helping you with that?
I got a place to stay.
Is that with family or with a friend?
Friend.
Okay. Is it in the Atlanta area?
Yes, sir.
Okay. You understand that the sentence that I'm going to impose today is probation for the most part, but you won't get out right away because you have to go down to Jonesboro to deal with whatever that is.
Okay.
I mean, you'll get transferred down there. You're not going to get stuck in Fulton, but you won't be released from jail and told when you're ready, go on down to Jonesboro. You'll be transported down there to deal with whatever those charges are.
Okay.
Okay. All right. Well, Mr. Cardbo, I find there's a factual basis for your plea. In June of last year, you got upset at some officers, did some things you shouldn't. Sounds like you got tased. That can't have been fun. I also find that your plea is voluntary. That means no one's forcing you to do that. And you understood that because at first you said yes, and you meant, no one's forced me. You agree no one's forcing you to enter this plea?
Yes, sir.
Okay. And a knowing plea just means you've understood what we've talked about. Do you feel like you've understood a conversation?
Yes, sir.
Okay. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Dilligard?
Yes, Judge.
All right, Mr. Cardbo, is it okay if someone electronically signs your name to the indictment indicating your misdemeanor plea?
Yes, sir.
All right, we'll do that. I am going to sentence you on count 1, which has been reduced to a misdemeanor, to 8 months to serve. And on count 2, which is another obstruction of officers, also to 8 months to serve. Those two will run concurrently with each other, meaning at the same time. And then finally, count 3 will be 12 months probation, and that's going to run consecutive to count 1. So you're going to be on probation for 12 months. That was for Moon and the officers. You're going to have 2 conditions of your probation. Well, there's always one, which is don't get arrested for anything. But the 2 special conditions are, number 1, you're going to meet with a doctor or a counselor and have a mental health evaluation to see if there's any treatment. Keeping up with the medication is one, but whether seeing a counselor or someone would help. That'll be the first condition. And the second is that you're going to need to do 40 hours of community service. I will waive your probation supervision fees. Have you been working recently, or is getting a job kind of tricky for you?
It's tricky.
Okay. What's the last job you had?
I was a teenager.
Oh, so way back when.
Yeah.
Okay, got it. So we'll waive the probation supervision fees. Like I said, you're not going to go to probation right away because you got to go down to Jonesboro to figure out what's going on there. Okay. Ms. Rios, anything else on behalf of Mr. Cardbo?
There, thank you.
Ms. Dilligard?
Nothing further, Judge.
Any questions, Mr. Cardbo?
Also.
All right. You ought to be on your way to Jonesboro this week. If not, reach out to Ms. Rios and we'll figure out what the deal is.
Okay, thank you.
All right.
Yeah, I'm very happy that this defendant, when he drops his pants and underwear, that he didn't swing something else than his fists against an officer. So yeah, keep your pants on, folks. Don't fight the cops, and keep your pants. Now, pants are prison. Pants are prison. In the safety of your home. Nobody cares what you do in the safety of your home. You can walk around. You might sit in front of a computer with a coat, shirt, and underwear. But that's not a crime unless you stand up. Why isn't mooning considered protected speech like the middle finger is? That's a discussion for a later time, for another stream. Oh, okay, everybody. That is just over 2 hours, and I have stuff to do. And tomorrow, because earlier somebody told me about in this courtroom there was a guy representing himself. I'm going to find it, and tomorrow we're going to watch it. And so everybody, thank you for being here. Thank you for allowing me to do this. It's always an honor. Hit the like button, and please hit the check if you're still subscribed, because I'm currently in a place where YouTube just removes subscribers. And so if you wouldn't mind, subscribe if you haven't, check if you're still subscribed. And but I will see you all back here tomorrow, and I think I'm going to send you off with one of my, let's see if I have it here. I'm going to send you off with one of my a new song I created via suno.com. If you want to create your own songs via suno.com, the link is in the description soon. So thank you again, and remember, folks, from me and Mr. Jingles, hug your family, unless your family's crap.